Sometimes in car accidents or slip and fall cases, it's not always obvious who's at fault. Sometimes there's more than one person at fault. Sometimes that person could be you. Does that mean you can't bring a claim? No. Florida, like most states, is a comparative negligence state. And the best way to explain that, I think, is to look at a verdict form. Even though most cases don't always go to trial, the verdict form is the form that's given to the jury at the conclusion of the case, and they fill it out, and that's what tells you if you win or lose, and if you've won, how much money your verdict is going to be for, okay? So what we look at on there is the first question. The first question is always this: was the defendant the legal cause of any of the plaintiff's injuries? Yes or no? If the answer is no, you've lost, the case is over. The second question, if they say yes, is, was the plaintiff the legal cause of any of their injuries? Yes or no? If they check yes to that, the third question is going to be this: please assign a percentage of fault to each party. So as long as, in Florida, as long as you are not more than 50% at fault, you can bring a claim. And what happens then, the jury verdict will have your full damages, and the judge will say, okay, your full damages were, say, $10,000, and the jury says you're 50% at fault and the defendant's 50% at fault, so the judgment's going to be for $5,000. The defendant's going to have to pay their share of their negligence of your damages, which is $5,000. So it's math at that point. The real question, and this is what we argue about before we get to trial, is whose fault? How much fault was on the defendant? How much fault was on the plaintiff? And that's all part of the negotiation. So don't let it discourage you from bringing a claim just because you think you might have, bear some responsibility for your actions. That's true, but that doesn't mean that you shouldn't get compensated for what the defendant did.